safe and healthy as you can, and that your family and loved ones are doing as well as possible given the circumstances. We are grateful to the Office of the Clerk of the Court and to the clerk himself, Joseph Stanton, and to Megan Sullivan for their extraordinary work in putting together the teleconferencing facilities so that we are able to provide parties with something approximating an oral argument in person so that their right meaningfully to be heard can be protected, including both presenting arguments orally and hearing the questions and concerns of the justices hearing their cases. This allows us to try to play better our role of preserving the rule of law during this difficult time, while it is under challenge in a number of different directions. So our gratitude to court staff, and particularly to Joseph Stanton and Megan Sullivan. We'll be hearing a single case this morning, number 19-114, Bay State Gas Company versus Commissioner of Revenue. The rules are the same as the rules in the courtroom, which is to say it's 15 minutes per side with no rebuttal. These teleconferences are on the record. They are being recorded. They are being streamed live. So you should know at all times that your cameras are on and your microphones may be on. I think that is all of what is relevant to this particular argument. So with that, we will hear first from Attorney Call for the appellant, Bay State Gas Company. And the timer, as you can see, is on the screen. I believe there may be some mechanism beyond that, but you should be warned, I believe, at 5 minutes and certainly at 90 seconds that your time is expiring. So with that, Attorney Call.
Thank you, Your Honors. May it please the panel. My name is Richard Call, and I represent Bay State Gas Company with co-counsel Robert Cordy. For corporate tax purposes, Massachusetts permits a deduction for most state taxes, including sales taxes, transaction taxes, property taxes, but there's a limited subset of taxes that it excludes from that deduction. Those are taxes on or measured by net income, franchise taxes measured by net income, and franchise taxes for the privilege of doing business. At issue here is the Indiana Utility Receipts Tax. Our contention is simple, that this looks and feels like a typical sales and use tax for which there's a deduction. Sales taxes are typically meant to be imposed on one transaction in a chain of transactions. That's the ultimate retail sale or consumption of a good or service. And that is exactly how this tax is structured. The tax is measured by retail sales. There's a sale for resale exemption, which means that wholesale sales are not subject to tax. There's an exemption for sales to the federal government because sales taxes cannot be imposed on the federal government.
Mr. Call, this is Judge Blake. Are you aware of any other states who have applied the theory that our Department of Revenue has applied to this particular tax? In other words, Bay State does business in many, many states, I presume. Have any other states interpreted the Indiana Utility Receipts Tax the same way that the ATB has?
No.
Has it been, have they found the opposite, or is there just no case on that?
There's no case on that. It's fairly rare that these type of taxes are at issue. I think most states recognize they're not. The one strain of cases across the country that's addressed these is New Jersey. And it hasn't found this specific tax to be exempt, but it's found several taxes on utility services and electricity or gas to not be subject to New Jersey's version of this statute.
Thank you.
I'm sorry, so are you saying that New Jersey allows the deduction?
That's right.
Okay.
New Jersey follows Bay State's position here. So the core economic pillars of this tax really are a sales and use tax. And what is perhaps the most surprising about the board's decision is it failed to even acknowledge that there's a use tax component in here. A use tax is unquestionably not an income tax or a franchise tax for the privilege of doing business.
Why do you
And yet,
say that? Can you explain that?
well, use tax is imposed anytime someone consumes an item. If I drive to New Hampshire, buy something at a store there, it's not subject to sales tax in New Hampshire or Massachusetts. But when I drive back across state lines, the tax is imposed for using the good. It has no relation to corporate income. It's that use tax is imposed on individuals or corporations, anyone that consumes a good. And I don't think the department would ever argue that a use tax could fall under this statute that we're talking about.
And it's your view that the defendant or the appellee has changed their theory on appeal? Is that, am I reading your brief correctly?
No, the commissioner hasn't necessarily changed his position on appeal. What happened for years, the Department of Revenue argued that this was an income tax under the words of the statute. Once this got to litigation, presumably because the department's issued clear guidance saying that this kind of a tax couldn't be an income tax, the department abandoned that theory and then changed to the theory that this is a franchise tax for the privilege of doing business.
Okay.
That strikes me as the critical point here, Mr. Call. There is a deduction allowed from this tax for depreciation. And I'll ask your brother about this as well. I gather that that is a feature that one would expect only from an income tax. Have you ever seen any a depreciation deduction from a sales tax, or for that matter, franchise tax?
To be clear, I've never seen that outside of an income tax. But if it was indicative of an income tax, the department's already conceded this isn't an income tax.
No, I understand. That's why I say that change of position may well be critical here. I'm not sure. I'm not sure that it is an income tax, but what would being called an income tax and having a deduction for depreciation, there's at least, right, there's some strength maybe to an argument that it's an income tax. But I agree with you that that's waived, and I'll ask your brother about that waiver and about the depreciation deduction.
It's also important to note what the depreciation deduction is for. This is for something called resource recovery systems. A resource recovery system, to my understanding, is something that converts some waste into something reusable. It looks like this is an environmental benefit or a tax aimed at a tax provision aimed at providing some environmental benefit. It was claimed 1 year, I think, by the taxpayer. We have no evidence of it being claimed by other taxpayers. So it's not large.
It's not depreciation on all sales producing property.
No, it's just a resource recovery system. It's a limited depreciation deduction. Typically a utility would have presumably very large depreciation deductions. That's not what's happening here.
Well, it's clear, isn't it, that this is some kind of supplemental tax on utilities. That is, presumably Indiana has a corporate income tax, presumably it has all the features of corporate income tax, including depreciation, deductions, and so on. It's a net, I assume it's a net income kind of tax system like we're all familiar with. And for that matter, they have a sales tax too, but this seems like some per unit rather small, although obviously cumulatively for Bay State Gas, it's $500,000 in this instance, but some small marginal additional type of tax with some small marginal additional depreciation deduction.
That's right. There's some marginal depreciation deduction. And as far as this being an additional tax, it is an additional tax. It's addition to the typical sales tax. And what happened when you look at the Indiana legislative history, they imposed this tax and then a few years later realized that transactions were escaping the tax. Just like the Massachusetts, New Hampshire sales tax issue that has been going on for years, there was a concern that, hey, state is trying to tax retail transactions, those are escaping tax because customers aren't purchasing from those vendors. So we need to adopt, Indiana said we need to adopt a corresponding use tax that taxes the transaction. If the sale is exempt, we'll tax the transaction of the use. But either way, it's the retail piece that's being subject to tax.
And Mr. Call, if we agree with you on the characterization of the tax, would you agree that we do not need to reach the constitutional question that you've raised?
Absolutely. There'd be no reason to address that. Our constitutional argument is merely that we're unaware of any tax that has a compensating use tax in the country not being permitted, a deduction not being permitted for that. So it wouldn't make sense and be unconstitutional to permit a deduction, for instance, on Massachusetts sales tax, which is imposed on the sale or use of electricity, but not do the same thing for Indiana.
So an as-applied argument if we had to reach it, but you don't think we do?
That's right.
When did Indiana adopt the compensating use portion of this tax?
I think about 4 years after the original tax was enacted. I think it was 2002 for the first tax, 2006 for the second one. And as explained in the Mirror and Sugar case out of Indiana, it was for the exact reasons that states have use taxes.
So if this case had come before the compensating use portion had been enacted by Indiana, what would be Bay State's position?
It would be still that this is a tax on the transaction, the retail transaction.
What would be the position, but why? I mean, it seems like to me, it seems here on appeal, your strongest argument, or at least the one that you lead with, is the fact that there's this compensating use portion. At least for some time, Indiana didn't have this compensating use portion. What would be your strongest argument in that scenario? The
strongest argument there would be that ultimately, Indiana is not trying to tax all of Bay State's business. The taxes that are disallowed here are taxes on the business. So Bay State's wholesale sales, they're not subject to tax. Bay State's sales to the federal government, not subject to tax. What are subject to tax are their retail sales. Now the existence of a use tax isn't what saves our position. It just essentially bolsters it, really in our mind, beyond question. We don't see this as a close call because of that. And it's important to note that the board never explained what a franchise tax for the privilege of doing business is. When you look at the statutory language, some historical context is really important.
They didn't quite say that this is a franchise tax. They said it falls within the category of the definition. I took that as a little bit of a hint that maybe they thought it was an income tax, but the commissioner had dropped that argument.
Right, the commissioner has guidance saying that a tax measured this way can't be an income tax.
No, I get it.
And to be consistent with that.
That's not a statute, that's guidance. And I mean, the way I read the board's decision was it seemed like a carefully crafted opinion that avoided actually calling this a franchise tax. I read it to say it is the type of tax that falls within this clause, period.
That's right. The board never clearly said what the standard was for these taxes. And again, historical context is important. In 1965, states across the country could call a tax. They could say in their statute, this is imposed on net income. They could say it's a franchise tax measured by net income, or they could say it's a franchise tax for the privilege of doing business. And that had constitutional significance for multi-state businesses. At the time, the US Supreme Court would strike down a net income tax if it wasn't worded appropriately. By 1977 and the Complete Auto case, the Supreme Court rejected that formalism entirely, saying.
And you agree that that the law of the Commonwealth rejects that formalism as well?
Yes, it has to, or then we would, fall back into this.
Well, I mean, it might create problems. They don't have to, right? But it would create complexity in terms of apportionment and so on.
That's correct. And the board essentially said here, because the statutory language imposed the tax on the receipt of taxable gross receipts instead of imposing the tax directly on transactions, that meant it wasn't subject to tax. But if you look at the full statute says the receipt of taxable gross receipts from transactions. The next two words, the board carefully omits every time in its discussion, from transactions. And you know, the U.S. Supreme Court has made it clear, if you impose this tax, they said a tax on sleeping measured by the number of shoes in your closet is a tax on the number of shoes in your closet. The board just fell into that error of following nominal imposition language and sticking with that. I think it's also important to note that the department advances a different theory here than the board. Well, the board never really advances a theory, but the department now says that the economic incidence of the tax determines its nature, or that taxpayer-specific facts determine its nature. The economic incidence of the tax plainly is the transactions, by the fact that the Indiana legislature realized that transactions were escaping tax and implemented the compensating use tax. And as to whether or not taxpayer-specific facts matter, whether Bay State has 98% of that entity's receipts are subject to this tax or 5%, it doesn't change the nature of the tax. There's 7 or 8 different utility services that are subject to this tax. The record only contains evidence of Bay State's services. Those arguments are all entirely irrelevant and really not appropriate here. For those reasons, we ask that the board's decision be overturned. Thank you.
Thank you very much. Very interesting case and excellent argument. Very helpful to us. We will hear now from Mr. Goldberg on behalf of the commissioner.
Good morning, Brett Goldberg for the Commissioner of Revenue, and may it please the court. The statute disallows deduction of taxes imposed on a business as a whole, on the business enterprise. For a utility in Indiana, the URT is a tax on substantially all of its operating income.
But as your brother points out, it doesn't apply to wholesale sales. It doesn't apply to government sales. There are exemptions. So it's not actually the whole business. It's a subset.
It's substantially all of the business, Your Honor.
And where is that test articulated, that these exceptions to the disallowance statute apply only to substantially all? Where's that?
The statute, we understand the statute, and I think both parties agree that the statute means applied to the enterprise in its entirety. That doesn't include all possible income. I think it must mean substantially all income. There's always exceptions to tax, to any income, any gross receipts tax. And these are, in fact, quite small exceptions for a utility selling electricity or gas in Indiana. The affidavit of our expert on utility regulation says, quote, "We have reviewed the rate case filings of several large and small Indiana public utilities, and in every case, over 80% of their operating revenues were taxable under the URT. For the majority companies, over 90% of their operating revenues were taxable under the URT."
I'm not sure I understand this argument. Are you saying that, let's pretend that one of those companies decides these retail customers are a big headache. They call up and say there's no electricity, and then I have to send a guy out to fix it. I hate that. So we're gonna just sell wholesale. That's what we're gonna do, except in Bloomington. My brother-in-law lives in Bloomington, and we're gonna hold on to our franchise to sell retail in Bloomington, but every place else it'll be wholesale. And now instead of retail being 80% of our business, it's 4%. Would your argue?
So far as I know, Your Honor, that just doesn't happen, that the regulatory regime dictates that if you are engaged in the retail sale of services, that's most or almost all of what you do.
How does it, I didn't see that in your brief. How does the regulatory regime say what percentage will be wholesale and retail? I don't understand that.
doesn't say that. I think what our position is that the regulatory regime, which imposes this rate-making process, that's the primary function of the regulatory regime, it is focused entirely on retail sale of electricity. And I don't, there's nothing in the record suggesting that there is or could be an example of a, like Your Honor is suggesting. And I think the situation is somewhat parallel to an insurance premiums tax. That likewise is a tax on a unique stream of income in a unique industry. But certainly it's clear, I think, and our directives take this position, that a insurance premiums tax is a tax on the business as a whole, because the insurance business is such that that's substantially all of what insurance companies do as an operating manner is sell insurance and collect premiums. So I think the URT is similar to that. As a result of the regulatory regime, substantially all of a Indiana utility is subject to the URT. That the record does support.
You also suggest in your brief, I think it's at page 39, that the plaintiff has taken inconsistent positions as between the tax in Indiana and Massachusetts. In Indiana, it's not, they consider it to be not a sales tax, where here they're asking that it be a sales tax. What is the legal import of that? Is there something that precludes them from, in one state, saying it is a sales tax and another saying it's not?
No, there's no absolute preclusion. It's more in the nature of an observation. It came up in the lower, at the appellate tax board, because we do have a penalty for inconsistent reporting. And there was an issue about whether that penalty applied.
And did the ATB assess that penalty?
It did not. The reason it gave was not that the penalty was inappropriate, but that the commissioner had not asserted it early enough. That is, the penalty, a penalty like this has to be asserted at the audit level. It cannot be asserted at the litigation level. The audit level, the auditors asserted a different penalty that was not appropriate. In litigation, we said, well, that same amount of penalty should be assessed nevertheless, because the inconsistent reporting penalty would apply. And the court said, no, you can't switch horses once you get to litigation.
So this is about, I think, $500,000 in tax. What would the magnitude of the penalty have been if it had been raised properly?
I'm sorry, Your Honor, I don't recall that.
That's okay.
Some tens of thousands of dollars. I'm sure I can get back to the court on that if you wish.
It's punitive, clearly, right?
Yes, obviously, that's what it's obvious in the case of an inconsistent reporting penalty that it's designed to discourage exactly this sort of behavior.
Well, I'm trying to figure out, Mr. Call indicated, and I'll ask you if this is also your view, that there are no cases that have decided the URT in other states other than what he referenced in New Jersey. So if this is in fact an issue of first impression, would the penalty even apply?
It's an issue of first impression whether this tax is within the scope of the enterprise taxes whose deduction is disallowed. That's different from the question of whether the taxpayer took inconsistent positions.
Okay.
Can I ask about the depreciation? For some reason, you've changed your position and you say it's not an income tax. Indiana says it's an income tax. It is clearly, well, it begins by measuring gross receipts, but of course, all income tax begins by measuring gross income. And then there is apparently just this one deduction, maybe there are two, I don't remember, for depreciation, which to me doesn't say franchise tax. Frankly, it doesn't say sales tax either, which is not to say this isn't one of those things, but if someone said to me, identify the tax based on this factor, there's a deduction for depreciation, I'd say income tax. isn't that what you, I mean, you're more expert, I would think, than I on tax law. Isn't that why depreciation is deductible? Because it's income generating?
Even in the gross receipts tax area, which is what this clearly is, some deductions are typically allowed. They're much more limited than for net income taxes. For example, the Texas margin tax, it is one of the taxes described in Directive 08-7, allows, I think, as an optional deduction, a deduction for depreciation. I think another option is total employee compensation. You can take one, but not the other. So all of these sorts of taxes.
And why doesn't that turn a gross receipts tax into a net income tax with limited deductions? The number of deductions on my federal income tax, I've noticed, has gone down and down and down, but it's still called a net income tax.
I think that's actually right, Your Honor, that the difference between a gross receipts tax and a net income tax is the number and amount of the deductions. For a gross, but the intent of a gross receipts tax is to tax regardless of profits, whereas a net income tax is looking to tax only profits. So they are distinct in that respect, but they do share the common characteristic of having some deductions.
And do you understand what property can be depreciated and deducted in Indiana? Is that clear to you?
Yes, I think it's clear under the statute that it applies to, I think they call it resource recovery, which seems to refer to, as Mr. Call said, equipment that is used to convert garbage or hazardous waste into energy. So the depreciation deduction is limited to that. In this case, it was not insignificant. It was $314 million, I think, in 2016, which was 15% or so of the income for that year, the gross receipts for that year. So it is significant. And Your Honor is quite correct that a depreciation deduction is consistent with a income or gross receipts tax and totally inconsistent with a transaction tax, because the depreciation is applied to aggregate income.
Or a franchise tax.
Yes, a depreciation deduction is consistent with any tax that is imposed on the business as a whole.
Well, let me ask you this about your position vis-a-vis income tax. It seems to me more likely that this is either a sales tax or an income tax than a franchise tax. Why have you abandoned any argument? I mean, you have, maybe it doesn't matter, but why have you abandoned any argument that this thing that's called income tax, that taxes gross receipts except for some deduction, why have you abandoned your position that it's an income tax?
The Directive 08-7, which we are bound by, clearly takes the position that a gross receipts tax is not an income tax within the meaning of the statute.
Even with deductions? Every income tax is a gross receipts tax with deductions.
I think the distinction between gross receipts tax and an income tax, and this is the distinction drawn in the directives, is whether they're intended to tax business profits or not. And a gross receipts tax is not intended to go after business profits. The department has taken this position that gross receipts, although income, is not income within the meaning, although it could be viewed as income, it's not net income, and therefore is not income within the meaning of the statute. I think that's a reasonable position. I think the other position is reasonable too, which is the position Indiana takes, that a gross receipts tax is a tax on income. It's a gross income tax. But I think both positions are reasonable. The fact that it is a gross receipts tax means, I think, that it is a tax on the privilege of doing business. And that's why it's disallowed in our view, not because it's a income tax, because we don't view gross income as income within the meaning of the statute.
What is your best argument in response to the portion of this Indiana tax that is the compensating use portion? That is clearly Indiana thought of this as transactional based. What is your response?
Two things, Your Honor. One, the fact that there was a delay of 4 years between the enactment of the original tax and the enactment of the compensating tax indicates that the legislature did not think it was a sales tax. Because
that's not the test. The test is whether it's transaction based. So as I understand your brother's argument, is that it sounds like a sales tax, and a sales tax is transaction based. So this one is transaction based, e.g. the compensating use portion. So I'm wondering why, even though this is not a sales tax, why it's not a transaction tax in light of the compensating use.
I think a transaction tax on retail is a sales tax. I don't know what else it could be. But in direct response to your question, the existence of offsetting or compensating taxes is not a feature that is unique to sales and use taxes. So the existence of a compensating tax just doesn't prove one way or the other whether it's a tax within the meaning of the statute. And the best example of that is the DirecTV case, where the legislature here enacted a tax on the satellite TV transmissions that was intended to offset the tax that cable TV companies were subject to even the playing field. And that's what compensatory taxes do, and that's what the use tax does, but it's not unique to the sales and use tax context.
Okay, your time has expired, so unless there are further questions from the panel, just Swenlin, no? Thank you very much again. It's a very interesting case, and your argument was excellent and quite enlightening for us and helpful to us. I'd like to thank all the counsel for your willingness to appear before us in this manner. And of course, I want to thank the court staff for their hard work in putting this together. That the case is submitted, and that completes our session for this morning, and consequently, we now stand in recess.
Thank you.
Thank you.
Thank you.